I used to work for an attorney that specialized in 35-year law, and he was spearheading class actions against Sony and Universal because they were denying every termination notice pretty much. So I'm curious if you've kept up with that and if you have thoughts on these major labels just refusing to give artists back their rights for those works.
That is a very good question. I will give some context for some other people. If you don't know, depending on who creates a work, there is a window of time where you can terminate a grant to someone else. And I think that the clearest circumstance might be, okay, I'm writing a book, I'm licensing, letting the publisher, just copy and distribute the book for sale. There's a window of time where, as we approach 35 years now, and there's some different there's a lot of different, copyright law is too complicated, so I'm shorthanding things. But the law says you can terminate that grant. You have to file a copy of the notice with the Copyright Office. You have to deliver it to the copyright licensee if you're the copyright owner, and you have to be a qualifying person to be able to do it. In any case, that is becoming hotter now because if you do a little math, 1976 Act, 1978 was like the year it was operative. At 35 years, okay, now we have some cases that people have been doing these for a few years now. Some pieces of that I can't talk about because we have a regulation related to that right now. There's also a pending case that we're at least keeping an eye on involving the Harper Lee estate. But these issues are really hot and will get hotter soon because, as you might imagine, the law was created for authors to get a second bite at the apple, so to speak. So like if they're bad contract, they're bad license, whatever, they could get out of it by operational law. They're going to try to. At the same time, there's a couple of issues involved with it that are, I don't even want to say unsettled, but like being discussed. One of which is the types of works that don't qualify for this are works made for hire. If you've ever seen a recording contract, they frequently say this work is considered a work made for hire. But the law says that a work made for hire can only happen in two circumstances. One is when you're an employee. The second is if it's a qualifying work and there's a written instrument. Sound recordings are not on the list of qualifying works. In most cases, performers, producers, whoever might be claiming the sound recording are not employees. There is a provision, however, that says compilations are included in the work made for hire provisions. And so from my understanding, a lot of the lawsuits are about that single piece where the labels are claiming, this is not every case, I'm just shorthanding, don't quote me on nothing, but they might be claiming that they own the rights in the compilation, and that's something that is not able to be terminated. There were three, I think the fourth one either got settled or tossed out, but class action lawsuits involving this. They're not finally settled yet. We'll see what happens. But it's something certainly to keep an eye on. The one other piece to know is that in that law, there's an exception for what we call derivative works. I made like a quick reference to that before, but like the shorthand hypothetical here is I write a book, someone creates a movie from the book, and that movie should still be exploited because we don't want to keep that new work from the public just because the license in the book was terminated. There's some debate over the extent of where that applies to, and that's the regulation that we're working on now, and it's got a lot of press. So because we don't have a final rule on it, can't really talk about that anymore right at the moment, but really smart question because it is one of those hot topics in music right now.